Ladies and gentlemen, good afternoon. I do hope that you have all enjoyed our luncheon today. I'd like to begin by asking if you could join me in a round of applause for those who prepared and served our food today. Also, this would be an excellent time, if you have not already done so, to please turn off or silence your phones and other electronic devices so that they do not interrupt our program. Also, pleased to let you know that today's event is being recorded for rebroadcast and for sharing with those who could not join us by our friends at CAN TV. So we thank them for being here today. As many of you in the room will recall, originally we were to have been joined today by Illinois State Police Director Brendan Kelly. However, Director Kelly had to withdraw from the program because today, the same date, was selected for the dedication of a portion of the Illinois tollway system in memory of fallen trooper Christopher Lambert, who was struck and killed by an impaired motorist on January 12th of this year. We are fortunate and indebted to have Oak Park Police Chief LaDon Reynolds, who graciously agreed to step in for today's program on behalf of the law enforcement community. So, Chief, thank you for being here. Those familiar with the traditions of the Union League Club of Chicago will know that we begin our public affairs programs with the Pledge of Allegiance, and today, following the pledge, which I'm about to lead, we ask that you please remain standing for a moment of silence in honor of Trooper Lambert and the 110 other law enforcement officers across the country who have lost their lives in the line of duty this year. And now would you please join me for the pledge, followed by a moment of silence, ladies and gentlemen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. If you would remain standing for just a moment of silence, please. Thank you very much. Please be seated. Ladies and gentlemen, today's program is part of the Public Affairs Committee's execution of our commitment to community and country here at the Union League Club of Chicago. We are the only private club in the United States that has an institutional commitment to public policy, advocacy, and community service. And a major part of that mission is gathering the community together to talk about the issues that matter to us all. And today's program is convened in that context, and we thank each of you for spending part of your day to talk about this very important new law that is coming to our state as of January 1st. Now, to get our program underway, it is my pleasure to introduce Senior Counselor of our Public Affairs Committee and the moderator of today's program, Mr. Chris Roebling. Chris?
Hey, thanks very much, David. Thanks to all of you for making time, coming out. It's a question of giving the people what they want, and they beat a path to the 5th floor of the Union League Club. So it's terrific to have all of you here as we note the very serious changes in public policy that are going on, and even in the last week or so, I guess, we've seen Michigan start selling for adult use, and lines out the door in Muskegon and whatnot, and I'm sure we'll be discussing some of those aspects of the pent-up demand for a legalized substance. I want to recognize Jerry Kern, who's the chairman of the Public Affairs Committee, and Nancy Ross, who's our first vice president, will be president next year. Club leadership is here, so we're not going to have too much fun today. We don't want, if they see it, you never know what's going to happen, right, Bob? You know, we got to keep it down the middle. Okay. I also want to say, in his absence, I am the luckiest moderator / co-chairman in the history of the Union League Club, because the co-chairman with whom I serve is a guy named Brian Daly. He's not here today, but without him, I'm not sure any of these things would, well, David would certainly force us to get it done, but without Brian, I'm not sure this would happen. So let's give Brian Daly a round of applause. You know, I'm really, let's see, my son, who was 20 2 days ago, told me that in response to "Okay, Boomer," I'm supposed to say something like, "Yes, Zoomer," or that there is now a response for people of the Cheech and Chong generation. No, it's Dave. Dave's not here. How many of us remember that? Come on. If you don't, there are actually young people today who don't know that reference. And so I always am turning on YouTube and playing the 80-second bit, which is as hilarious today. The chief of police is here. We got to really watch out. But we can have fun talking about this stuff. You're not going to enforce any warrants or, okay, that's really great. Man, what a great guy. Oak Park, you can count on them. Anyway, it's a big change going on. And if you're in the investment community, you've been hearing about it. If you're in the healthcare community, you've probably been talking about it. If you are in the public policy community, you've been evaluating it. And the state of Illinois has gone through all of those stages, and it's come to a new place. And we thought it was a terrific idea to help folks get acquainted with that. And that's why we've got our, sort of vectors into this. Kelly Cassidy has been the leader down in Springfield, I think it's fair to say, or one of the leaders in Springfield, in deference to her colleagues on this. So she's going to start us off with her sort of 5-8 minutes on how we got to where we are and what are the distinct features, and then take a seat. Then we want to hear from the chief on his law enforcement vector into this issue, and then, of course, Matt Luzader, who is practicing attorney, counseling clients, telling folks, you do have to worry about this, you might not have to worry about that, let's find the way to get it done. That's the kind of contribution we want to make with this lunch. So please join me in a big Union League Club warm welcome for State Rep Kelly Cassidy, who's going to get us going.
Thank you so much. And to your point with about Cheech and Chong and all of the others, what we've discovered over the 6 years I worked on this bill, the jokes pretty much write themselves. They're mostly unavoidable. So if I am accidentally punny, please forgive me. As I said, 6 years ago we started walking down this path. When I came into the General Assembly in 2011, we were just about to pass the medical cannabis program. Which took some time to get up and running, was one of the least robust programs from a patient-facing perspective in the country, but very quickly became the regulatory model for the country. We hosted delegations from states weekly who wanted to see how we built our regulatory model because it was working so well. And ironically enough, when I first started working on the adult use bill, I really expected folks in the industry to ask me to relax some of the regulations they were operating under, because my perspective was, business wants less regulation. That seemed like a safe assumption. And I was pleasantly surprised to find that these guys actually really like the structure they're working under because it gives them certainty. It's not regulation for regulation's sake. It's regulation for the sake of having a safe industry that is well managed. So we started from that foundation. And there are some things about it we didn't like. Those of us who were working on the bill, I was instantly joined by State Senator Heather Staines as my Senate sponsor, and we very quickly grew our family to what's been referred to in the press as the marijuana moms, which, we don't like the use of the word marijuana, and we're more than moms, but okay, you take the labels you're given. And that included State Senator Toy Hutchinson and State Representative Jahan Gordon Booth. We were joined by many others, including Selena Villanueva and Bob Morgan, who were invaluable in getting this over the finish line. But this was a multi-year project, and Heather and I started out from the perspective of, we've got these rearview mirrors. We've got these other states who've gone either medical or adult use. At that time, we had, at the beginning, I think we had 8 states that were adult use. And we saw that as a huge resource. And so we started reaching out either by phone or by traveling to these states and asking, what do you wish you had done differently? What do you wish you hadn't done at all? What do you wish you could have done? And literally, every single one of them said, I wish we had done it via the legislative process. Because every state prior to us had done this through a ballot initiative. Ballot initiatives are written by the people who can afford to be in the room to get something on a ballot. And as a result, around the country, what we see is an industry that doesn't reflect the communities that they're in, isn't built thoughtfully around what it is to end prohibition and what it means to undo the harms of the war on drugs. And that was our lens from the beginning. And we really had the opportunity to do that by doing this through a legislative process in a very open and transparent way. Over the course of the 3 years that we worked on specifically on this language, I put tens of thousands of miles on my car. We had dozens of town halls all over the state. We had hundreds of stakeholder meetings. There were several meetings with folks who, somewhere within the first few minutes, they would say, why do you care what I think about this? This doesn't affect me as a chamber of commerce. This doesn't affect me as a university. Like, yes, it does. We're going to change the framework of our state's systems, and we want to make sure we're thinking of everything we can as we do this. And it was, I'm as wonky as they come. I loved every second of it. But there were lots of moments where we wondered if we were missing anything. And we did a lot of work looking at the case law around the country. What we saw in terms of the question of diversification of the industry, every state tried something. You have to try something, right? Most of them tried race-based set-asides, and every single one of them had those thrown out in court as unconstitutional. And as a result, what we see is an industry around the country that is estimated to be about 4% minority-owned. And that's not okay. And again, we started from that place. Read a lot of case law, read all the decisions. Those decisions are a roadmap on how to get it right. What did the court not like? What did the court tell you could have done instead? And so that's how we came to this equity model that we have in this law that is based on social equity applicants. If you read all 700 and some pages, I lost track of where we landed, there will not be a single mention of race anywhere in the bill, because that has been the thing that's been the tripwire in every other state around the country. So we created a system by which folks who have been disproportionately impacted by the war on drugs, so that those are areas, they're from areas that we defined as disproportionately impacted areas. We used data such as numbers of cannabis arrests and convictions in those communities, poverty rates, violence rates, returning citizen rates, and used those to help define the disproportionately impacted areas. In order to be qualified as a social equity applicant, you are either from one of those areas or have an arrest or conviction for a low-level cannabis charge that we made expungible under this law. That is the thing that hasn't been tried anywhere else. That is the thing that is underway now that we're hearing news reports about the application process. And we actually also put a hard pause in to make sure that if this doesn't work, we can try something else. So what you're going to see on January 1, the existing medical operators who prior to our law operated with a complete veil of secrecy over who owned the companies. Those records were not FOIA-able. There was no way to tell. So people would ask me, how many more minority owners are there in the industry? The fact is, we couldn't tell them because there was no requirement that there be any transparency about ownership. We took care of that as well in the new law to make sure that folks know who the owners are and how they're operating. So we knew that we were starting from this excellent regulatory foundation, but not such a great business model for moving forward, not a great system for the consumer or the patient. So you're building on a good regulatory foundation, but not a great business foundation. So we had to repair for that. So the repairs for that begin with the social equity model. After the first round of licenses are let in May, there will be a hard pause on new licenses being released so that we can do a disparity study, so that we can do a demand study, and make sure that as we look at this, we are accomplishing the goals we set out to do to make this the most equity-focused industry in the country. Within that space, we are very mindful of the fact that in every state that has legalized for adult use, there have been shortages on day one. There have been lines around the block on day one. We saw photos out of Michigan where they moved up their first day of sales because we were both supposed to start on January 1. Okay, guys. So we saw lines there. Again, using that rearview mirror that we saw around the country, we actually put in place safeguards for patients in our system so that patient access to medication comes first. Before Cheech or Chong gets to make their purchase, Susie the cancer patient does. And we're requiring that these facilities, because we keep such close track of the product and the sales, they know exactly what they need for their patient base. People are attached to a dispensary, patients are attached to a single dispensary. They know what they're going to need. So all of these facilities are required to set aside a sufficient product to make sure that patients get access so that we, at minimum, I can stand in line, you can stand in line, but we want to make sure that the patients get first dibs. Again, something unique to our system. So as we move forward, January 1 is an important day, but it's not the most important day. For me, my measure of success is going to be a year, 2 years, 5 years down the road when this market matures. Does it look the way we intended it to look when we started this process? And I'm not going to lie, I've been in the General Assembly since 2011. People really like instant solutions. They like silver bullets. They like the answer to the problem rather than a set of answers to a set of problems and a thought process that gets us to a full solution in multiple years' time. But that's the way we're doing it. We're doing it in a very slow and deliberative way to make sure that we can get it right, that we can correct for any errors that might have been made. Reversing 80 years of prohibition, reversing 80 years of disproportionate impact on on communities of color is not something that happens with the flip of a switch, with the snap of a finger. This is the first bill on this. This is not by any means the last. We've talked about this a lot. I have a lot of friends in legal states in their legislature, and we all keep in touch with each other and check in with each other with some regularity. And in every year in Colorado since legalization, there have been a dozen or more cannabis-related bills introduced. Parallel here, we carry a lot of alcohol bills every year. We reversed prohibition a long time ago, but we every year debate what alcohol policy should look like, and that's going to be the reality with cannabis as well. January 1 is day one. It's not the finish line. It's the starting line. And I think that we will see a lot of changes over the years as we are able to course correct, and we've built in to be able to do that. I'm proud of what we've accomplished. I'm excited to see where we get, and I'm looking forward to taking your questions because Stump the DJ is way more fun than Talking Heads.
Okay, good afternoon. So thank you for inviting me to speak on this topic. I'm excited to be here. I will add that because the law has been enacted, I've been promised that this is not going to be a resurgence since it's Christmas time of Oprah's favorite things. There's no bag of weed underneath your seat, okay? No bag of weed. All right. So that being said, let me just say this. If you give me a minute to briefly indulge you, I want to touch on a couple of concepts. Number one, the role of police in society or the police mandate. And then secondly, how this mandate translates into the initiatives based on the new cannabis law. So quite simply for me, and I can only speak for my position as chief in the Village of Oak Park, the role of police can be found in the preamble of the Constitution for the state of Illinois. Let me just give me a second to read it. We, the people of the state of Illinois, grateful to Almighty God for the civil, political, and religious liberty which he has permitted us to enjoy, and seeking his blessings upon our endeavors in order to provide for the health, safety, and welfare of the people, maintain a representative government and orderly government, eliminate poverty and inequality, assure legal, social, and economic justice, provide opportunity for the fullest development of the individual, ensure domestic tranquility, provide for the common defense, and secure the blessings of freedom and liberty for ourselves and our posterity. do ordain and establish this Constitution of the state of Illinois. I think the police mandate, the role of police in society, can be found in those words. There are 17,985 different police agencies in the United States, and they are represented by county sheriffs, city and state police departments, federal law enforcement agencies, and our founding fathers purposely designed our system so that policing is managed at the local level. In short, the goal of every police organization as they facilitate the administration of justice is to police through the collective consciousness of the communities they serve within the standards set by law and industry best practices. So, for us, the role of police as it relates to the new cannabis legislation, simply put, is analogous to alcohol, okay? According to Merriam-Webster, the Department of Government, this is the definition of police, the Department of Government concerned primarily with the maintenance of public order, safety, and health, and the enforcement of laws. It also says they possess executive, judicial, and legislative powers. I don't know about that. But to that end, the focus for the Oak Park Police Department was to provide a three-pronged approach to this new law. The first being education. I think part of the police mandate is to make sure that the adults, the youth, all citizens in the community, all people in the community have the appropriate information that they need in order to educate themselves and their loved ones on the issues surrounding any intoxicant, okay? So to that end, we'll talk to adults, youth, we'll use our school resource officers, we'll talk to public and private schools through our community policing unit, and also we have partnerships with the third sector and social service organizations. From an enforcement standpoint, I submit to you that in no time in the history of policing have we used the power of arrest to sustainably find a solution to a problem, okay? So the war on drugs is a failure. We all know that. Drug abuse and addiction is an identified health concern. The illegal profiteering of drug abuse and addiction is also a criminal matter. Additionally, irresponsible use of intoxicants to the extent that it endangers the life and safety of others is a criminal matter. So our enforcement efforts will be targeted in those spaces. So from a DUI perspective, I don't know of any chemical tests that they have available now to detect THC in the blood. However, I'm sure some enterprising young person is working on that right now, and they're going to make a lot of money doing that. But for now, we have what we call a RIDE program. It's the Advanced Roadside Impairment Driving Enforcement. This program trains our officers, and our Oak Park police officers are going through this now, to identify and articulate the signs of impairment related to drugs, alcohol, or a combination of both. And this is to reduce a number of impaired driving incidents, reduce fatality crashes, and injuries. From a medical personal use standpoint, our goal is to ensure that the users don't infringe on the rights of others for a smoke-free environment. So to that end, we'll partner with the Department of Public Health for the Village of Oak Park. We're one of the only municipalities that has one. We'll also partner with the Cook County Board of Health. We're going to provide services that include health assessments, screenings, education, prevention, case management, nursing, counseling, and access to other community resources. The bottom line is we have to have a common sense approach to this new legislation. We can no longer be siloed in public safety. So the concept of community policing dictates that we collaborate with all available resources in the community to address the needs of people. That really is the definition of community policing. So there are also regional concerns that may come to bear, such as organized crime or, again, addiction. So we'll use partnerships to address those concerns. So we have federal, state, and local partnerships to address organized crime issues. I don't envision the Oak Park Police Department or any other police department kicking in people's doors, measuring their plants and things of that nature. But we will take a common sense approach to it. We'll also partner with other community resources, the township, other non-for-profits, and we'll use that information that we have to make sure that our community members have the resources they need to address any concerns, whether it be addiction or abuse or what have you. We'll also engage in community forums, which we already do, and we'll consider all demographics. Everybody isn't web literate, so we'll have community meetings and public service announcements available to educate the public on the information they need in order to facilitate that learning process. And then also from a business regulation standpoint, we'll partner with our business communities through our Development Customer Service Department to talk about the security for those individual establishments and proximity to school, number of licenses, things of that nature. So, and also nuisance abatement. You talk about the lines. That can create a public hazard as well. So we'll address those things. So in closing, let me just say this. The two most important and expensive choices that anyone makes as an adult is where they choose to buy a home or rent, and if they have a family, where they choose to educate their children. In choosing our state, they're making a significant investment, right? They are in effect buying a zip code. The police are part of the return on that investment. Just as we expect our investments in the private sector to gain in value, the police must create public value with every interaction. And getting back to the Illinois Constitution, how do we ensure the blessings of liberty for ourselves and our posterity? And that's by treating all persons with dignity and respect, in policing with the collective consciousness of the community, and know that we're providing that return on investment in all of our interactions, creating public value. That's all I have. Thank you.
Good afternoon, everyone. I'm a lawyer, right? So I'm often asked by clients a variety of different questions. This question regarding Illinois' legalization has come up a lot recently. Everyone sort of thought that January 1 was way off in the distance. It's approaching a lot quicker than anyone thought. And so what I'd like to share with you today is sort of my take on issues that employers are facing, and sort of the questions that we're being asked here. And I'll just do a poll of the room. How many people in this room are responsible for supervising employees? Good portion of the room. You might want to just keep your hands up. How many of your companies have an HR policy, an employee handbook that covers drug and alcohol? Look, you are more than half of the way there towards having a policy and being able to address legalization of marijuana in Illinois. There are some concerns. They're not as dire as anyone says. I mean, the statistics out there are that, and I'm sure Representative Cassidy can speak to this, that when a state legalizes marijuana, you don't see like a giant jump on this. I mean, there are those employers out there that think that, beginning in January, everyone's going to be showing up to work high. That doesn't happen. And frankly, the secret is those employees that use marijuana and are showing, they're already showing up high to work. If they're going to do it, they're doing it, right? So how do you educate those employees, and how do you educate your supervisors? How do you address it? So there's three key concerns that are always raised, right? One of them is workplace safety. The other one is compliance with laws and regulations. And the third one is, how do I avoid litigation? Now, there's a fourth one that sort of factors into those, the chicken little, the sky is falling. I'm going to have, massive reduction in employee productivity once we legalize marijuana. I'm going to throw that one out, right? Because there are other ways that you should be addressing employee productivity other than saying we're now going to, mandate everyone to undergo a drug test here. And we'll get into some drug testing here. But I think that the core thing, and we've heard this from other speakers up here, is that people want certainty, right? So the three key things that a company needs to have is make sure you've got your policies in place. And as I said, you've already got everything you need already in your HR toolbox. You already have an alcohol policy that you can use for addressing an impairment at work. And you've already got a policy that probably addresses the prohibitive items, right? You're not going to let somebody take a gun to work, just like you're not going to let them have let's say a bong at work sitting on their desk. You can prohibit that. The other thing is that no company anywhere in the U.S. is required to accommodate marijuana usage at work, period, right? All these laws have been drafted to say you're not required to let an employee take a smoke break so they can go outside and consume marijuana on it. And the third thing is, this is where it's really important here, is that training aspect, that putting the policies in place and communicating it to your employees on what your expectations is. Because at the end of the day, what employees like, just like companies like, is certainty. They want to know what they're supposed to comply with and how they can be using things, at work, before work, what your drug testing policies are. So as long as you got those three things in place, you're fine, right? And when you put those three things in place, there's three product categories that you need to address. And one of them I'm going to throw out there, and that's CBD, because this comes up for employers all the time. They're like, I have a drug testing policy. I have an employee that says that they're using CBD and it's going to cause a false positive, sort of like, we've referenced Cheech and Chong. How about Elaine and the poppy seed muffins, right? Remember when Peterman's White Lotus that was causing a false, CBD does not cause a false positive on marijuana tests. It may lengthen the lifespan of the THC metabolites in your body, but there's a lot of things that can do that, but it's not going to cause a false positive. The second thing is sort of separating out where you have medical marijuana usage pursuant to a prescription and where you have recreational marijuana usage. And as an employer, you need to kind of divide that stuff out. Now, in these brief opening remarks, there's a couple things that I want to highlight. Of if you're in specific industries, you need to pay very careful attention to. One of them is if you are a federal contractor. If you are a federal contractor, you're required to comply with the Drug-Free Workplace Act. Now, the next question is, does that require drug testing? The answer is no, it does not. You just have to have a reasonable drug-free policy at work. So we can kind of put that to bed because that's been one of the biggest questions that we've had. We represent construction companies and metal fabricators and defense contractors that are all very concerned about whether or not they need to start testing for marijuana as this legalization expands. The second thing is if you have any employees that fall under the Department of Transportation, right? So commercial driver's license. The Department of Transportation has been very clear, and they say it every time a state law gets passed, they reissue another statement saying, hey, just making it perfectly clear, if an employee fails a drug test and they say, but I have a valid prescription for marijuana, that does not negate the test. You're required basically to fire them at that point. So you have to be conscious of if you have employees that have a CDL. The third thing is that if you are a contractor or somebody that works on Illinois Public Works projects, and this is one of the things we have going on in Illinois, is we've got a couple of different acts in place, including like the Workplace Privacy Act and this Drug-Free Public Workplace Act. I'm probably getting the title wrong here. They kind of conflict with each other a little bit, but that, as far as I understand, has not changed. And if you're working on an Illinois Public Works project, you're still required to have drug testing procedures in place for the employees that are working on that. And then for employers, going back to that first concern about workplace safety, this is where you've got, let's say, a factory, or maybe you're just a software developer. How much stuff is actually affected by the legalization of marijuana? Do you need to have drug testing policies in place, either pre-employment or, let's say, worst case scenario, post-accident, and for what positions, right? And for that, we can kind of look at OSHA's guidance to decide, for a company, and this is where you've got to do that pre-planning, which positions am I going to require pre-employment drug testing for? If I'm going to have random drug testing or mandatory drug testing during the course of the employment, and then if it's post-accident, am I going to test or not? And looking at OSHA's requirement, it's not that you have to drug test after every workplace accident or injury. Obviously, things like repetitive injuries, carpal tunnel syndrome, why would you drug test an employee if they're filing a claim for that? Right? Or if it's something where a safety guard has been removed from a machine and it's been off that machine for a long time and somebody suffers an accident, not drug related. Now, somebody dropping a pallet off a forklift and crushing somebody's foot, yeah, maybe you'd want to test the forklift driver. But you also need to make that consideration of whether or not you're going to test the injured employee who was just maybe an innocent bystander at the time for having their foot crushed, because one of OSHA's concerns on this is that we want to make sure that employees are reporting workplace accidents and they're not just sort of saying, well, I'm afraid I'm going to get drug tested, I'm going to fail, therefore I'm not going to tell my employer that this accident has happened. So you have to have those processes in place and understanding, when am I going to drug test employees, and then B, what are my procedures if I think an employee is showing up to work impaired? And Illinois law, and I'll just summarize it here quickly on it, and the governor just signed an amendment yesterday that clarified an employer's liability for taking adverse employment actions, terminating, firing, suspending an employee who they suspect is impaired, you're protected as long as you have a good faith basis. And that's where it comes in, your existing alcohol policy. What are the physical traits that you are observing and documenting? And keep in mind, I always advise, everyone always has two people, HR and maybe a manager that is there that both observe it, so it's not one person's word against somebody else's. What are the physical signs? What are the behavioral signs? Are they not paying attention? Are they uncoordinated? And having those sort of set out ahead of time. And then also, what are the job performance functions that they're not meeting? Are they tardy? Are they missing details? And being able to document all those so you can justify a good faith basis for taking action against that employee. Now somebody says, well, if I have an employee that I think is impaired, why don't I just go ahead and drug test them? Well, my first response is, if you have everything you need to already take action against an employee, why would you drug test them? I mean, first of all, the problem with drug testing for THC, and most of the folks in the room may know this, is that the indications of consuming marijuana can stay in the human body for up to 30 days, 45 days. I mean, one of the sad facts is that because of some restrictions with the ability to test and do scientific research on these things, we don't have a lot of definitive knowledge or products developed, like I'm sure the chief would like, where you can do a roadside sort of breathalyzer for marijuana consumption on this. So you can't tell if that employee consumed off the clock or on the clock in the first place. And second of all, they're expensive and it's time consuming to have somebody come in. I mean, a urine analysis test can cost $30 to $60, and that's not just counting the time that it takes for you to administer it. A blood test, even more problematic in terms of getting consent to conduct it, and those can cost up to $300. And forget about a hair analysis, right? I mean, those can go back 90 days, and what do you care at that point, right? So if an employee is impaired, you've already got those tools in your toolbox. You can follow those. I think the main message here is don't panic. Just take a reasonable approach, right? No one's going to be, I'm advising my clients, don't start doing mandatory drug testing just because you have a fear that you're going to have employees that are showing up and impaired at work. Work through the problem, and you've already got sort of those tools there that you can use to address it. So again, specific instances where you have somebody that has a prescription for marijuana, going back to that, and says I'm going to test positive on this drug test because I'm using marijuana to treat something like chronic pain. Go through your ADA, your Americans with Disability Act, process of communication with them to sort of figure out if there's a reasonable accommodation there or if there's something else. But address that underlying issue, not going right to, marijuana's legal in Illinois, we've got a problem, we've got to test for it. So that's all I got.
Terrific. Thanks very much, all three of you. Those were terrific comments. And this part of the program really belongs to all of you. David Cohn is here. He's got the microphone. So here we've got a hand up. All I ask is that you please, David, right over here.
Okay.
And please stand and identify yourself. David will hold onto the microphone. Please, no speeches. And here we go. Here's our first.
Yeah, as we like to say, we ask that you phrase your question in the form of a question.
Hi, thank you. I'm Dr. Yerkes, Illinois Congressional District 3, People and Principles Over Money and Power. Although I see some merits to medical marijuana, I'm opposed to legislative of recreational marijuana for a vast number of credible reasons, including a vast number of increased deaths due to increased usage. My pertinent question: as a father, I advocate for the DARE program to keep our kids off of drugs. I think there should be a DARE program for adults. Ms. Cassidy, why don't you agree with my educational and informative approach?
Actually, we set aside a significant portion of the tax revenue from cannabis sales in Illinois for treatment and prevention, specifically targeted at youth use and adult use as well. So that is already part of the program.
Okay, we have another question over here. Can you state your name, sir? I'll hold the mic.
Thank you. William Walden. Senator Cassidy, before yesterday evening, the HR community and the employment law bar would have recognized that there were clear limitations to being able to take action against somebody who was adult use in the workplace. The amendments have made that a little bit less clear, and so many of us are asking whether or not at this point after the amendments, can an employee be terminated or action taken against the employee simply for the positive drug test, even if the usage was off work and there was no impairment in the workplace?
Yes.
Thank you.
We worked very, very hard both in the original bill and in fact, the original bill was described by folks like the Illinois Chamber and others as the gold standard for employers. There were questions raised over the summer. We tweaked it to make sure that people understood this. I also do want to point out, though, to some of the points you made, as we used those rear view mirrors, one of the most significant things I learned, workers' comp claims and costs did not increase in Colorado. They're our greatest measure, right? They've got the longest track record, and we've not seen the problems that folks worry about there or elsewhere. But we made clear that the ability of an employer to maintain a zero tolerance policy is absolute. And you know this. These cases are working their way through, in particular around medical cannabis patients, and we're getting dueling court decisions around the country, and that's eventually going to sort itself out.
Yeah, no, that's exactly right, because you've got decisions. I mean, New Jersey has like a Compassionate Care Act that you're not supposed to discharge an employee who has a valid medical marijuana prescription for it. But what I'm telling you, employers are this that ask about it. It's not going to stop you from getting sued, right? I mean, if you fire somebody for a positive drug test, they may come back and they may say you didn't apply this in a consistent manner. And that's where that training comes into effect, right? Is to make sure that if you're drug testing employees, that you've got it set out and the employee knows, look, you are a forklift operator. We are going to randomly drug test you. Or you are a software engineer. We are not going to randomly drug test you, but if we have a reasonable suspicion and we can articulate that we think that you're impaired at work, we are going to drug test you. Putting that certainty in place, I think, certainly helps insulate the employer, and having HR and management just check to see how, particularly, massive, large companies, how drug tests are being administered.
I'd like to ask Chief Reynolds. We're talking about drug testing, and we're talking about the sort of workplace context. Sure. And you've referred, obviously to the question of public safety. And so, for instance, the roadways, the highways and byways. Yes. I think we all have a sense of, if you have a glass of wine or something at the Christmas party, you can drive yourself home and you're going to be okay. But if you have a six-pack of beer, or if you have 3 vodka and tonics or something, you're in trouble, right? Okay. So does the Oak Park Police Department have your toxicological staffers or your pharmacological staffers given you a 1 joint or 2 joint? What is it? What's okay? What can people consume before they're crossing that line out there?
So I don't have the answer to that specific question. What I can tell you is that they're driving and they are impaired based on the performance on the road, then we're going to treat that as if driving under the influence. So, I would imagine the levels would be different for different people at different weights and different body types and sizes. So for us, we're just looking at the behavior. I think that's what you should address, is the behavior. And so if someone is driving and they appear to be impaired, that's what we'll address.
State Representative, have you done your job?
I believe we have, and we started it many years ago before we even did this. Illinois didn't have a standard for testing. We had a zero tolerance. Any presence of THC in your blood was sufficient to attempt to prosecute for DUI, but what we found is that it was hard to make that stick. And so we adopted the same standard being used in Colorado, Oregon, and Washington, which refers to nanograms per deciliter of THC in blood or saliva. We enabled the use of a saliva test. It's not in widespread use yet. Only Carroll Stream has field tested it here in Illinois. Too small to be useful. We actually looked at and modeled after Michigan what they did. They did a really sweeping 5-county controlled study on the use of the cheek swab. They're fry testing it now. It's been fry tested in California. So we're getting there. But to your point about a vodka tonic or a 6-pack of beer, that's a dynamic substance for humans as well. Like we think 0.08 is a magic number because we've been told it is. It's not. And we moved that around for a long time too before we landed on 0.08. There is the fundamental distinction that THC stays in the system longer than impairment does. And so I love that Oak Park is focusing on impairment. That's one of the things we really pushed in our discussions with law enforcement is drug recognition experts are going to be your most useful tool to address impairment. Because that's the reality. But I think we're going to see a lot of movement on this. We've created a DUI task force explicitly to stay on top of the science so that our laws can stay on top of it.
Okay.
Let me add one thing.
Yes, sir.
And we're not at the bar with anyone looking at how many drinks they take. So
Right.
we don't know.
Right.
It really is about the behavior.
Okay.
Another question over here.
Yes, hi. My name is Matthew DiCiani. Representative Cassidy, I just wanted to clarify something you said earlier. Can an employee be terminated solely for testing positive for cannabis? What about the Right to Privacy in the Workplace Act that prohibits an employer from disciplining someone from using cannabis outside of work? I mean, we all just said that cannabis stays in your system for 30 days, so couldn't they just say that they consume cannabis outside of work?
With a reasonably applied zero tolerance policy, yes, you can be fired. It's really that simple.
Solely for testing positive
Yes.
for cannabis?
Yes. If it's reasonably applied, if that is if your stated policy is that this is a zero tolerance workplace, yes. But you have to have the policy in place and it has to be applied fairly and in a non-discriminatory manner.
And that's where it becomes sort of incumbent upon employers to now take a look at their HR policies and make sure they've got that clearly set out, what those parameters are. And if they're differentiating between positions, that they have a business justification for differentiating between we're going to test for this position, but we're not going to test for that position.
And I'll add, again, using our collective rear view mirrors, what we've seen in Colorado, I learned a new phrase on one of my first trips out there, dangerously low unemployment. You reach a point where you've got to contemplate whether you can find people to do the work you're trying to hire people to do. And what we've seen in Colorado is either an abandonment of drug testing or they've developed a 6-panel test instead of a 7-panel test. They stopped testing for cannabis in many cases just to be able to actually have a functional workplace.
Although there is a third path there, and I do a lot of work in the construction industry where some of the Colorado construction companies are actually recruiting out of state because they're working on federal projects and they're afraid that they're not going to be able to get enough, and they haven't been able to get enough qualified candidates in Colorado that can pass the test.
Question over
Okay,
here.
question over here. Your name?
Name is Brad Bayaki, and thank you for all being here. The question is about is transportation of, we talk about taking it, but transportation to, from work. I mean, we all go to the Metro and you have a beer there and people are doing it before or after work. So how is that going to be handled?
So there is a prohibition on public consumption still. So you're not going to see people sparking up on Michigan Avenue. But we do enable local governments to create social use spaces, social consumption spaces, because one of the things we saw in other states was the same disproportionality of enforcement of possession just sort of transferred over to disproportionality in enforcement of public use. So you start with that. There's no public consumption, period. In fact, yesterday's story was you can't even sit on your front porch, and you can't. It cannot be in public view. But the question to the transportation specifically, when you go to the dispensary and make your purchase, it's given to you in a sealed container. Just like you can't have an open container of alcohol in your car, you can't have an open container of cannabis in your car as well. The smell of cannabis in your car is still probable cause to search. So you're going to be wise to continue to use those store-issued smell-proof containers.
Have I
Right
a question over here?
Here's RD.
Just a moment.
This may be outside the scope of expertise here, but how does the federal law impact? I mean, is your firm taking money from cannabis suppliers, and does that violate the federal law on money laundering and all kinds of issues that come up with the federal laws? There's a Safe Banking Act that's been proposed, but I don't think it's gone anywhere yet.
Go ahead.
Allow me, thank you for raising this, and I wonder if we could take this federal jurisdiction question and identify sort of 2 or 3 different layers, one of which would be law enforcement, another of which is capital accumulation and the anticipated reforms at the federal banking level, which would then open the public markets to funding these companies. And I think we should also look at some of the legal questions that arise on the 219 South Dearborn side of the coin as opposed to the Daly side. Okay, so State Rep.
Sure. So obviously we knew that this was going to remain illegal at the federal level as we were working our way through this, and it's something that we talked to other states about as well. During the process of crafting this bill, our existing medical industry, which at the time was about 85% banked, all in one bank, the Bank of Springfield, the Bank of Springfield made the decision to push them out and cancel their accounts. So we had an industry scrambling to figure out what to do on that level as well. So we did everything within our power as a state government to address the various pieces, including banking. We have language in there to make sure that state chartered banks and credit unions have some level of confidence about banking the industry. We made sure that we addressed questions of interstate commerce to the extent we could. But the federal law needs to change. The Safe Banking Act actually passed the House. We have not seen action yet in the Senate, but they're a little busy there right now. I guess the Senate probably won't get that busy because I doubt there'll really be a trial, but that's another panel for another time. But the reality of the Safe Banking Act at the federal level, it's inclusive of the hemp industry, and McConnell is very, very heavily invested in the hemp industry. So I think that there's a pretty decent chance that the Safe Banking Act will pass, and that will help. Truth is, it needs to be descheduled. That will solve all of the issues.
I will say this because this aspect of it I speak on quite frequently. In addition to doing employment law, I'm also a certified anti-money laundering specialist and advise financial institutions in how to safely bank cannabis businesses, both on the hemp side and on the marijuana side. It's being done. Banks are providing them services, as Representative Cassidy said. Across the nation, a lot of it's just risk management. It is extremely expensive to maintain an account. I mean, some of these accounts, they're charging $5,000 a month just for a simple checking account for a business, and that's because they can't lend against those assets, right? They're not FDIC insured on that. It does need to change at the federal level, but there are financial institutions that are frankly comfortable with it as long as the right sort of KYC, the know your customer, and the anti-money laundering monitoring controls are in place on the back end. They're fine doing it, and frankly, the Department of Treasury is fine with them doing it because FinCEN, which is an agency under the Department of Treasury, they receive what are called suspicious activity reports that are secret, but they do publish bulk numbers, and we know from the published numbers that there's 489 or something from their last report, financial institutions that are banking marijuana businesses out there because they're filing suspicious activity reports on them, and they're sort of following. There's a big deal made about the Cole memo. I don't know how many folks have heard about the Cole memo, but when Jeff Sessions came in as the AG, he rescinded the Cole memo. Every U.S. attorney's office that we've talked to about this has said we're still following the Cole memo, right? It's we want to make sure there's not diversion of funds. We want to make sure that there's not diversion of product and sales to minors and involvement of organized crime. with those real law enforcement priorities in mind and not just going out and hunting for a marijuana business for the sake of hunting for a marijuana business, banks are providing services to these folks. And I always like to point out, and then I'll stop, that since it went medicinal legal in California in 2009 and rec legal in Colorado in 2012, there has not been any financial institution who has been prosecuted for banking a legal marijuana business.
I think my part of the question's been answered.
I'm not so sure,
It's still scheduled.
Chief. I think you've got a couple of...
We have another question over here to the panel's left.
Whoa. No. I'm not kidding here.
Okay. I've been cut off by the moderator.
Chief, I want to know, I mean, how does this change your work stream, okay, with your federal partners? Let's leave the whole ICE thing and all of that kind of, for all I know, Oak Park is still a nuclear-free zone, but let's just talk about your work stream with your federal partners. Sure. Has the state representative and her buddies down in Springfield erased a whole area of your 2020 work plan?
No, so I have officers assigned to federal task force, and it is still a scheduled substance, and so we are still pursuing more large-scale issues as it relates to marijuana transportation and distribution. But yeah, it's illegal, and from a federal standpoint, they're still being pursued.
And to be clear, we are not legalizing the street market. That's still got to be taken care of.
Yep.
So you know that's a huge difference, and that's a big distinction.
Okay. State your name and your questions.
Hi, my name is Philip Chandler. I'm a social equity applicant from the south side of Chicago, and many of us are concerned throughout the application process that regulators are more so focused on who can bring the most money to the table as opposed to actually being social equity applicants. Can you clarify?
Well, there are no points given for how much money you have on your scoring. So no, to that extent. You know, my bigger concern is you know, making sure that the applicants are getting the technical supports that are needed, that we get the loan fund up and running, and we can't get the loan fund up and running unless the existing licensees are paying into it and being able to get opened. That's $30 million, again, something no state's ever done to get your business up and running. And there's going to be huge volume of applicants. There's going to be a tremendous volume. I was just talking to somebody who's running one of the incubators who's got 45 clients ready to apply. And that's a drop in the bucket. So in terms of, you know, how well capitalized you are, there's no points on your license application for that.
Okay, question in the back, man.
Hi, I'm Erin Surratt. I'm out of Peoria, Illinois. I actually have a question about the allocation of the taxes. So 5% of the taxes are going to go back to mental health services. How is that going to be distributed in Illinois?
It's more than 5%.
Okay. How is that going to be distributed in Illinois? Is it going to be based on where those taxes are coming from?
No.
Or is it going to funnel into...
It's through the state grant funding system that exists for mental health services.
Okay. So is it going to take away...
Nope.
Any of the already funded?
Nope.
Fantastic. Thank you.
Sure.
Chris, can I interject a quick question? It's come up often during the debate on the legislation and post-enactment. With the legalization of recreational cannabis sales through licensed facilities, the idea is, at least in part, to undercut the street or black market, right? So can you, Representative Cassidy, address the thoughts or the discussions that occurred among you and your colleagues about how this was going to emerge? It's going to be obviously rather expensive, but hopefully not so expensive that the black market or the street market continues to thrive. That was the part of the idea. So how does the new law address that, or how do you think it will address it?
So, and again, you know, you're going to hear me say we could have a drinking game over rearview mirrors, but you know, looking at what some of the other states have done, we were concerned to make sure that our tax rate wasn't too high. I'm not in love with our tax rate. I think that we should have come in a little bit lower, but that's the nature of a collaborative process. But we saw other states that had to drop their tax rates because you saw competition with the street market and the legitimate market. What we do know is that it takes about 5 years for the market to mature. So our revenue estimates are based on that knowledge, based on that ramp. It takes time to habituate folks into the regulated marketplace for a couple of reasons. One, it takes a minute to get somebody to break up with their weed guy. These are long-term relationships. But also, there is that realization that there's a lovely and very real difference between, that product line that's available from the kid on the corner as opposed to the product line that's available in a store where you can go in and talk about your desired outcome. I want to treat my hot flashes. I have chronic pain. My elbow hurts. And being able to choose a product specifically targeted at that. It's a lot nicer to go into a store than to sneak around the corner. It's really nice to know that there are no dangerous pesticides or mold or other contaminants in your product. But that's a learning process for the marketplace. We assume about a 5-year ramp.
Well, let me pick up on that since we're an agricultural state. What are we saying to our vendors about growing and about quality and supply and consistency? I mean, when we're talking about whether it's a pesticide or a drug, we've got purity, we've got stability, we've got consistency. What is it in Michigan? If you're selling in Grand Rapids, then you have to be growing it. You're the grower and the seller, and you've got to meet certain standards. How have we approached the agricultural issue?
So we currently have 20 licensed cultivation centers. We are not, so what you just described in Michigan, where the grower is the seller, that's called vertical integration, and that's really, frankly, a way to keep a lot of people out of the marketplace. So you can talk about it in terms of it being a quality control piece, but we've never had vertical integration. We've got 20 different cultivators. We've got 55 open dispensaries. You are permitted to be a grower who owns a dispensary, but you're not required to be. So that's really the toggle switch. Some states do vertical integration, some states don't. But we have very, very strict testing and labeling guidelines. This is not your brother's Ziploc baggie or film canister. There is the labeling requirements have to show not just the name of the product, but the potency, the date it was tested, when it was produced, that it was found to be free of a significant list of various contaminants, and where it was tested. So you get that information on your product labeling, so that we know this. And so anybody who's producing these products has to conform with these testing standards, has to conform with these labeling standards, and that's the only way to get a product into a store.
Okay.
Well, another question right here. Sir,
This might be our last one, or maybe one more.
Hi, Doug Moran. We're all glad that you're here, and I appreciate you answering our questions. And I hate to harp on this again, but I'm also in the employment area. Was the purpose in amending the Right to Privacy Act merely to cover those employers that don't have reasonable policies, or was there another intent for that? Because it seems to have some conflicting protections, if you will, and employers are really asking that question of, do I have to deal with this, or if I have a policy, I'm done with it? It sounds like the policy, you're fine. So what was the intent of the other?
I'm not sure how to answer that, to be honest with you. This was written in conjunction with employment lawyers. So I think that touching that was leaving it blank would have been too vague, frankly. Not touching it would have been too vague and caused other litigation.
Just as a follow-up, are you saying then that if you have a policy, the Right to Privacy and Employment Act does not apply?
I would ask your employment lawyer that. I can't give legal advice.
I
can't give you legal advice.
Yeah, so that Right to Privacy Act has a carve-out that refers back to the Cannabis Act that says that you can have a reasonable no-tolerance policy. And I think what that addresses is for those employers out there that says, regardless of whether or not I'm a federal contractor or have DOT-regulated employees, I want to have a zero-tolerance policy. And it gives them that freedom to do that, to say, I am only going to hire employees that can pass a drug test.
Kelly, Matt, Chief, come on. Let's hear it. Come on. Hey. In these, you can You can consume controlled or normal substances. It's really up to you, but if you show up at the Union League Club on a cold day, you'll probably get a free hot chocolate. Isn't that right, Bill Nissen? Yes. All right. Ladies and gentlemen, we really appreciate you coming. If you like what you're seeing and you're not a member of the Union League Club, we'd probably love to have you. This is commitment to community and country, and it's something that we live every day. It's a part of our legacy, who we are, what makes us, we think, important to the community. And this community is the one that we care about, the folks who come here and help us see outside these windows into the great region of Chicago and the state of Illinois. Thanks very much. See you next time.